Good morning. Good morning, Sheldon. From the SIU, Mr. Nechikweta and Mr. Lekheto, you can give them the rights for sharing.
So Mr. Lekheto and Mr. I'm just seeing where they are. Are they on the platform?
Yes.
Okay, I see it there. Thank you.
Thank you.
Good morning, Andre.
Good morning, Chair.
Yes, are you able to do a roll call?
I am, Chair. I will do the roll call, Chair. Miss Mochikatsi,
Present.
Mr. Dr. Kigaba,
Present.
Mr. Three, Mr. Three is on the platform. Mr. Chance,
Good morning, I'm present.
Mr. Gama,
Good morning, Andre. I am present. Thank you.
Mr. Mdluli.
Good morning, Andre and Chair. I'm present.
Chair, those are members on the platform. Some may have joined us while we on. Mr. Mkutu has just joined us as well, Chair. But we may proceed, Chair.
Morning, Chair, morning, colleagues. My apologies for missing the.
Thank you. Thank you, Mr. Tren. Thank you very much, colleagues. Can we fly to the agenda? Can we get the mover and seconder for the agenda?
I move that we adopt, Chair.
Thank you, Honorable Mdluli moves. Honorable Fefe, Mgudu.
Second, Chair.
Thank you very much. The meeting has been seconded. Are there any apologies?
Chair, we just received an apology from the CEO of the NLC who's not able to attend, Chair. But there are not from any members, Chair, at this stage.
Okay, thank you very much. This is a follow-up briefing with the SIU and NPA. Unfortunately, through officials who could not get hold of SAPS on the developments in terms of the investigations and or prosecution in relation to the alleged corruption and maladministration at NLC. The purpose of the meeting today is for a special investigation unit and National Prosecuting Authority to provide update on
recording in progress
and alleged corruption and maladministration at the NLC and any prosecutions that are related. As you know, that last time we did have an update from these entities. We will be following up with SAPS as it relates to that. I will now hand over to the, I'm not sure whether the minister is here. If not, I will hand over to the, yes.
Ms. Matomela is on the platform, Chair, if the minister is not yet, Chair.
No, I'm talking about we had invited the Minister of State Security, of Minister Kubai.
I'm not going to see yet, Chair.
Okay. So I will now hand over to the person who's going to be heading the report by SIU, and probably just request that having gone through the report, there's a lot of background information which was already shared. if we can really try and not spend a lot of time on those the mandate and what you do and so on, so that we can get into the actual case. How much time are we allocating to the SIU?
We gave him 40 minutes, Chair, depending on the 40 minutes.
If we can stay within that allocated time, and over to you. We'll take both presentations and then from there discuss. Thank you very much. Over to SIU.
Good morning, Honorable Chair and honorable members, and the NDPP. I see NDPP is on the line, and also my colleague from the SIU and colleagues from the NPA, and also the chair for the NLC board, and everybody in the platform. My name is Leonard Lekgetho, and I'm the acting head of SIU. So we will be presenting the progress update on the SIU investigation at the NLC. I'm waiting for my colleague to share the presentation. If Mashudu, you can share the presentation. Otherwise, it's fine. Let me do it, Chair. I hope it's visible. Let me put it in slide mode. Yes. Thank you, Chair. That's the presentation from SIU. And I'll take from what you have just said that we must leave the issue about the introduction of the SIU because we have done that before. But just generally in the outline of the presentation, we're not going to talk about the SIU and the motivation proclamation process, but we'll go straight to the NLC proclamation and also outline the modus operandi and the key role players that are involved in the NLC corruption and the instruments of the NLC corruption, the enablers, investment funds, and all other issues. So without wasting time, I'll skip all these other slides, Chair, so that I can give to my colleague, Mr. Mashudu, to present. Mashudu, you can come through.
Thanks, HOU. Thanks, Chair. My name is Mashudu Lakinechikweta. I'm the Senior Manager investigating NLC, leading in NLC investigation. In late 2020, SIU received a proclamation R32 of 2020 with two allegations or two focus areas. So the first focus area was to investigate the investment of funds by National Lotteries Distribution Trust Fund, established in terms of Section 21 of Lotteries Act. The second focus area was to investigate the allocation of money in the fund of beneficiaries who were not entitled thereto in terms of the applicable provisions of the National Lotteries Act. Sometimes last year on the 10th of October 2025, the initial R32 proclamation was then extended by Proclamation R293 of 2025, published on the 10th of October 2025. So the terms of reference in this extended proclamations were a little bit different to the first one. In the first proclamation, we were not given the permission to investigate procurement matters. But in this extended proclamation, two things happened. The first one was to give SIU powers to investigate 21 procurement projects, and also extended the investigation period of the R32 of 2020, which means initially the investigation was commencing on the 1st of January 2014, ending on the 6th of November 2020. The investigation has now been extended till the 10th of October 2025. So there are several procurement investigations, and in total there are 21. I don't know whether I should read all of them, or members have already read those 21 matters.
Proceed, Masiri, proceed.
No, you can proceed. You can proceed and read. We're just saying the background information because it's properly explained. The rest, remember, it has to be on record. So you
Okay.
can return it. Yes.
Okay. Actually, can you move to the first one? Back to the first one. So the first procurement matter that we are investigating is the appointment of a panel of attorneys or firms and legal practitioners in terms of bid NLC /2020 to 05. The second matter is the appointment of a service provider for a comprehensive employee wellness program for the employment of NLC in terms of RFP 2021 to 15. The third one is the extension of the appointment of Metrofile for offsite storage of documents and delivery thereof from 1st January 2021 to the 31st of March 2021. The next one is the appointment of a service provider for the procurement of electronic board pack in terms of RFP /2020 to 006, RFP NLC 2019-006, and bid NLC 2020-006. The appointment of a service provider for editorial on Back to Basic magazine. Submission for approval, deviation from normal procurement process, independent media, Arena Holdings, and Media 24. The appointment of Mail and Guardian for media roadshow through a deviation from normal comparative bidding. A contract with a service provider for the provision of MPLS services on the 12th of May 2016. A service level agreement for the rental of managed print services for the period of 1st June 2018 to 31st of May 2021. The appointment of a service provider for travel, accommodation, and conferencing as it relates to the fourth license RFP process. Placement of advertorials in the Sunday World newspaper. A flash mob activation, Women 2021 celebration involving MSG Group Sales and LC Scope Digital Solutions. The appointment of Neo Solution in October 2017 for the development of a company secretarial knowledge hub strategy. The appointment of Neo Solution to investigate a potential hacking incident involving the electronic board pack. The appointment of Age Consulting in June 2019 for the implementation of an Oracle Fusion system. The appointment of ProEthics to provide services in relation to ethics. The appointment of Workforce Health Care in September 2019 for the provision of employee wellness services. The appointment of SQS Quantity Surveyor in 2019 in January 2018 for project managing the acquisition of provincial offices. The appointment of Maluk's attorneys in April 2021 to a panel of legal service providers. An education and awareness broadcast campaign related to the purchase order dated the 29th of October 2020, and accommodation and travel services rendered by Regency Apartment Hotel and deal transfers. By or on behalf of NLC and payments which were made in respect thereof in a manner that were not fair, equitable, transparent, comparative, or cost-effective, or contrary to applicable legislation, manual, guidelines, practice, notes, circulars, or instruction issued by National Treasury, or manual codes, guidelines, policies, procedures, prescribed instruction, or practices, or applicable to the NLC and any related unauthorized, irregular, or fruitless and wasteful expenditure incurred by the NLC or the state. So when this investigation started back in late 2020, we had to face our investigation. So we had phase 1, which was finalized some couple of years back. We also had phase 2, which was also finalized. We were supposed to finalize the phase 3 in December last year, but because NLC proclamations are open-ended, we keep on receiving a lot of allegations while we are busy with our investigation. So as a result, we were unable to finalize phase 3 of our investigation. So we intend to finalize phase 3 on the 30th of June this year. We also received 690 new allegations that we are currently investigating. We have combined the allegations that we received from R32 with the new proclamation. So we are of the view that we will be able to finalize the investigation on the 31st of March 2027. We have also submitted one presidential progress report. Currently, we are about to finalize the second progress report that will be submitted to the president. The modus operandi by people who are siphoning money out of NLC. The problem that was uncovered was the proactive funding provision in the NLC Act that was targeted by those who were siphoning money out of NLC. Secondly, it is the NLC official and some board members who colluded with NPOs and NPCs to siphon money from NLC. This was done through the abuse of NPO and NPCs, and in numerous instances, hijacking of existing NPOs and NPCs. The SIO identified the following to be the root cause: inadequate project management, lack of monitoring and evaluation, ineffective auditing techniques for projects, general maladministration in the approval of the grants, system not geared to detect abuse, and corruption element. Key players in the NLC corruption. So we've got a number of people who were integral in the siphoning of money out of NLC. We've got internal people and outside people. In terms of internal people, the people who played critical role in the siphoning of money out of NLC are the Prof. Nebutanda, who was the board chair at the time, Advocate Huma, who was also a board member, Ms. TCC Mampane, who was the CEO at the time, Mr. Livingstone Ramatsekisa, who was proactive fund manager, Mr. Tsietsi Masela, who was head of legal, Mr. Philemon Litwaba, who was the COO. All these people benefited from funds that we looted from NLC directly. People from outside of NLC who were working directly with individual within NLC are Mr. and Ms. Shandukani. They used their company as agents to loot money from NLC. So the funds from NLC were looted using the foundations and companies from Mr. and Ms. Shandukani. We've got Mr. Malwanje Suweya, Collins Chisimba, Temba Mabunza, Mr. Karabo Sitole, Daisy Litwaba, Tabo Litwaba, Johannes Litwaba, and Ms. Promise Karim. Then we'll move to the instrument that we used in order to siphon funds out of NLC. So they used companies such as M. Shandukani Holdings, Rasimati Family Trust, Iron Bridge Travel Agency and Events. Maybe just to explain further, M. Shandukani Holdings belongs to Mr. and Ms. Shandukani. Rasimati Family Trust belongs to Mr. Litwaba. Iron Bridge, Mr. Litwaba. Abrent Properties, Mr. Litwaba. Musokodi Water Solution and Drilling, Mr. Letwaba, Musokodi Farming, Mr. Letwaba, M. Shandukani Trading, Mr. and Ms. Shandukani, Nzuku Trading, by Mr. Swema Lwandle, Musokodi Trust, Mr. Letwaba, Kaunawi is a proxy for Mr. Letwaba, but owned by the cousin, Red Tech, Mr. Letwaba, Ramuripo Trust is owned by Leslie Ramuripo, AO Trust is owned by M. Shandukan, Mr. Mashudu Shandukan, Danger Family Trust by Leslie Ramuripo, Letwaba Family Trust, Philemon Letwaba, Mujahomu Family Trust, the former Commissioner, Ms. Mampan. Some of the NPOs involved in channeling funds to the NPOs. So majority of these NPOs, we have already submitted our civil litigation documents at the tribunal in order to recover the funds. The first one is Simba Community Development, which was granted an amount of 25 million rand and 89,000 rand and 736 rand. Some of the funds that we paid to this NPO benefited Mr. Philemon Letwaba's family through Upbrand Properties, and also the Commissioner Mampane with the purchase of the 3.6 million rand house for her benefit. The second one is called Audacious, which was awarded an amount of 206,000 rand. The NPO was hijacked by Mr. Lukuleni, a former employee of NLC in Mpumalanga. There is an NPO called the Sidibe Foundation, which received grant funding of 1,445,000 in Free State. The funds from this NPO were also channeled to Mr. Chueni, a former manager operations of NLC. Nothing was done, so the project was not delivered. The next is called Rihodile Community Development NPO, which received an amount of 15 million from NLC. The project was also not delivered at all. The funds were channeled to the families of Mr. Philemon Letwaba. The next one is NPO called the Simingaye, which was awarded an amount of 13 million. The funds from this project were used to purchase furnitures for Prof. Nebutanda and other immovable properties for Mr. Sigudla. The next NPO is called Make Me Movement, which was funded for an amount of 17,792,000. The funds from this project were used by a person called Jacob Ramuhashi. He built a B&B called the Mountain Village. He also transferred some of the money to the transfer attorneys for the purchase of Prof. Nebutanda's house. The next one is called Ingabo Yokulinda NPO, which was granted an amount of a total amount of 19,278,000 rand. 2 million from this project paid for the purchase of Prof. Nebutanda's 30 million house. 10 million was transferred to a certain gentleman, but not for the purpose of the project. The next one is called the ORNA NPO. The NPO was hijacked and an amount of 23 million was awarded to the project for the construction of old age home in Northwest. The funds from this, some of the funds from this project benefited Prof. Nebutanda, who was the board chair, and Philemon Letwaba. The next NPO is called Tusong Development Organization. It was also hijacked in Soweto, but the application was submitted in NLC Kimberley office. This the entire 2.5 million was used by people connected to NLC including Mr. Huhuntle Matseke, who was an employee of NLC at the time. The third one is a company called ZZET Enterprise. This is the company owned by the wife of Mr. Sibonelo Vilakazi, who was an employee of NLC in KZN office. He then used his connection to NLC to assist the wife to receive an amount of 26 million from the crashes that submitted an application to NLC. The next one is an NPC called Spirinex that received an amount of 3,943,000. The entire project benefited Mr. Sigudla. The next one is it's a hijacked NPO called Lulamisa Community Development. The NPO received an amount of 80 million. The entire 80 million was not used for its intended purposes. The 80 million benefited Prof. Nebutanda, Mr. Litwawa, Mr. Siweya Malwandle, Mr. Mashudu Shandukani, and Temba Mawunza. The next one is an NPO called Uprising Youth Development. The hijacked NPO received an amount of 5.5 for a sports project in the Northern Cape. The entire amount was not used for its intended purposes. And the people who benefited from this project are Mr. Collins Chisimba and Mr. Jacob Ramuashi. The next one is an NPO called Mushumo Shabazwanda. It was also hijacked, and an amount of 20 million was then funded for this NPO. The funds benefited Mr. Advocate or Prof. Nebutanda and Mr. Collins Chisimba. Some of the funds also went to Mr. Litwaba. The next NPO that was granted an amount of 10,850,000, it's an NPO called the Nyumbiseni Batsonga Machangana. The entire funds was used to benefit Mr. Temba, to benefit Mabunza Brothers, together with Mr. Suweya Malwandle. The next one is an NPO called Hanyanyani. It was funded in an amount of 13 million rand. The hijacked NPO funds benefited Mr. Collins Chisimba and his wife, Ms. Promise Karib. The next NPO, which was also hijacked, is called Limpopo Creation Providers. It was granted an amount of 9 million, and the entire amount benefited Mr. Collins Chisimba and Mr. Ndowini Mukutu. Another NPO, it's called South African Youth Movement, which was granted an amount of 22 million to construct a drug rehab in Mpumalanga. I can say that the drug rehab has been constructed, but 6 million from that grant funding was transferred to Upbrand Properties for the benefit of Mr. Philemon Litwaba. Another, again, the very same NPO called South African Youth Movement in Free State was awarded an amount of 30 million to construct an old age home. The old age home was really constructed, but an amount of 5 million was transferred to two companies owned by Mr. Letwaba's families. The first one is L Holding. The second one is Just Cubana, which was owned by Mr. Letwaba's wife. After the construction of this old age home, instead of utilizing the building for old age home, Mr. Sigudla used this building to house student, or used it as student accommodation for his personal benefit. The next NPO is called Hatelopili, which was awarded an amount of 885,000 rand in Kimberley. Mr. Petra Sidibe and Johannes Khoza used the funds for their own personal benefit. This is the only matter that we submitted a criminal referral in NPA in Kimberley, where the Hawks conducted the investigation, concluded the investigation. The two gentlemen were arrested. They are currently attending court proceedings. The last one was on the 1st of March this year, where their lawyer told the court that they are going to plead guilty, but there were some differences between the prosecutor and the lawyer in terms of the sentencing. The lawyer wanted suspended sentence, whereas the prosecutor wanted straight jail. The next one is called Muteo. Again, this NPO belongs to Mr. Petros Sidibe. He was funded an amount of 9 million rand. He was paid 6 million rand, and the entire 6 million rand that he received, he used it for his personal benefit. There is another company again called TS Sidibe. It also belongs to Mr. Petros Sidibe. He received an amount of just over 1 million in Limpopo. He also used the entire amount for his personal benefit. There is an NPO called Special Agent for Youth in Kimberley, which was awarded an amount of 20 million, just over 20 million, and the project was built, but majority of the funds were used for the benefit of Mr. Mark Barons, Mr. Collins Chisimba, Mashudu Shandukani, and Mr. Philemon Lidwaba. The next one is called Fire Charismatic. HOU, can you, because I can't see the document now. So Fire Charismatic also received an amount of just below 3 million for diamond and dooring in Kimberley, but the entire amount was used for the benefit of Philemon Litwaba's family and Collins Chisimba and Matozi Mashel. You can move to the next page. The next NPO is called Zipsy Mode. It received an amount of just over 20 million rand for circumcision, but the entire amount was not used for its intended purposes. The beneficiaries are Prof. Nebutanda, Pietro, Mr. Siweya, and Philemon Litwaba. The next one is Zipsy Bigs, that received an amount of 5 million rand. Their project also benefited Prof. Nebutanda and Miss Petro. Another one is called Zipsy Craft. It received an amount of 4 million rand. The project benefited Prof. Nebutanda through the purchase of a house. The next one is called Madumelane NPO, which was hijacked in Northwest. It received an amount of 14 million rand. The entire 14 million rand benefited Advocate Huma, who was a board member at the time. It also benefited Mr. Ndowenu Mukutu and Mr. Collins Chisimba. The next one is called Litabong, which was hijacked in Polokwane and submitted an application and received an amount of 23 million rand for the construction of an old age home in Northwest. The old age home they tried to construct, but the hijackers left the project at foundation level. The funds of the project benefited Mr. Litwaba's family, Collins Chisimba, and Miss Matozi Mashel. The next one is called Taung Cultural Museum and Music Expo. It was awarded an amount of 20.1 million. The museum was constructed in Northwest, but some of the funds benefited, or the construction company belongs to Mr. Philemon Litwaba's family, and some of the funds benefited Advocate Marcelo, who was head of legal at NLC at the time. The next NPO is called Light Up Your World. It received an amount of 10 million. It was also hijacked, and the entire 10 million benefited Mr. Collins Chisimba, his wife, Miss Promise Karib. The next one is called the Kensani Nyango Foundation, which received an amount of 2.5 million. The whole amount benefited Mr. Howard Mashaba and Miss Kensani Nyango. The next NPO is called Matieni. It received an amount of 23 million. The NPO was hijacked in turn, though. It was awarded an amount of 23 million to build an old age home in Marapiane in Mpumalanga. The old age home was constructed, but it was not completed. Some of the funds were transferred to the benefit of Advocate Huma, like 5 million rand was transferred to our transfer attorneys in Northwest for the purchase of a house. Some of the funds were then transferred to the benefit of Philemon Litwaba. The next project is called Life for Impact in the 21st Century. The NPCs received an amount of just over 10 million rand. The entire amount was not used for its intended purposes, and the beneficiaries include Mr. Litwaba, Malwanje Siweya, and Themba Mawunza. The next hijacked NPO is called the Nje Primary Care, which was awarded an amount of 27,585,000. 6 million was used to renovate an existing drug rehab in Pretoria. The rest of the funds were then used by Mr. Leslie Rambulipo to buy properties such as farm and restaurants. Advocate Huma also benefited together with Philemon Litwaba. Philemon Litwaba's family received 6 million for the through Upland Properties. The next project is SASCOC stroke M. Shandokani, because M. Shandokani submitted an application through SASCOC as a conduit. The project received an amount of 24,830,000 rand. The entire amount was not used for its intended purposes, and Philemon Litwaba, through his family company, received 15 million. The remainder were shared amongst people like M. Shandokani through his M. Shandokani Holdings. The next project is M. Shandokani Foundation, which was awarded 4 million to drill and install boreholes in Eastern Cape. Our investigation has uncovered that the boreholes were not installed, and that the funds were transferred to the company belonging to Mr. Shandokani's wife and Mr. Litwaba's wife. The next NPO is called the Samaritan Initiative, which was hijacked by Advocate Huma, who was a board member at the time, and received an amount of 16.5 million rand. The chicken farm was constructed in Marikana, but that chicken farm was constructed in a land belonging to a company called Silverlight, and that Silverlight company is wholly owned by Advocate Huma, which then means that the beneficiary of the project was Advocate Huma. The second NPC that received an amount of 4.6 million rand is called Riahile. Riahile is an NPC of whose director is Advocate Huma's wife and nieces. Again, the project was constructed, or the project has a lease agreement with Silverlight, and the director of Silverlight is Advocate Huma, which then means that the beneficiary was again Advocate Huma. The next project is called Zipsilo, that received an amount of just below 26 million rand from NLC. The funds from this project, even though a drug rehab was built in Pretoria but not completed, majority of the funds were transferred to the attorneys, the transfer attorneys, for the purchase of a property to the benefit of Prof. Nebutanda. The next project is called Zipsimanzi NPC, which was awarded an amount of 4.8 million. The NPC is owned, or the director of the NPC is the wife of Mr. Philemon Litwaba. And some of the funds from this project benefited Prof. Nebutanda, who was a board chair at the time. The next project is called Nunovation Africa Foundation, which received an amount of 31.9 million to construct a boxing arena in the Eastern Cape. Instead of constructing that boxing arena, they constructed a small hall in Eastern Cape, but majority of the funds benefited Mr. Philemon Litwaba's family, Collins Chisimba, and Mr. Mashau, who hijacked the NPO. The next NPC that received an amount of 18 million is Saada NPC. The funds from this NPC benefited Mr. Arthur Mafokate himself as he purchased a BNB in Midrand for himself. Some of the funds he used for his personal benefit. The next one is called Ubuso NPC. That received an amount of 23 million rand. So immediately when the first tranche of 20 million rand was transferred, 15 million or 14 million of that 20 million benefited Prof. Nebutanda and Philemon Litoba's family through their family companies. So in this investigation, we are concluding this investigation, but there is also a property that has been purchased. But because we haven't given the person who benefited the right of reply, we are not going to mention, but we'll finalize the investigation soon. In order for people connected to NLC to siphon money out of NLC, they use the companies and trust. And these are some of the trusts that have been used in order to launder money out of NLC. The first one is called Rasimati Family Trust. The trust belongs to Mr. Philemon Litwaba, who was the NLC CEO at the time. There's also Litwaba Family Trust. There is also Mujahomu Family Trust belonging to the former commissioner, Ms. Mampane. There's also a trust called Ramulipo Family Trust, who's Mr. Nkumeleni Leslie Ramulipo, who hijacked several NPOs and received grant funding. So they used this one, including the trust called Musokodi Trust, belonging to Mr. Philemon Litwaba. We also have professional enablers who assisted NPOs. So as previously reported, one of the important requirements in submitting an application for grant funding at NLC is that the application form must be accompanied by 2-year audited financial statement. The SIU find that some of the NPOs or NPCs that did not meet the requirement for NLC application and were enabled by certain accountants to submit fraudulent financial statement for the purpose of NLC grant funding application. None of these enablers are registered with professional bodies, but we spoke to IRBA. They communicated with us to say that even though these accountants are not registered, but because they acted as accountants, they've got powers to discipline them. So we have submitted the documents to them. Next page.
Move on, Masudi. I've slided. Move on.
No, it's not moving on my side.
Yeah, we can present, we can see it.
The slides are not moving on my side, so I can't read.
Can you still see?
Okay. Yeah, now, yeah. Now the page has moved. The investment of funds. So one of the focus areas is the investment of funds by NLC with various financial institutions. One of the mandate bestowed upon the SIU in terms of Proclamation R32 of 2020 is to investigate the investment of funds by NLC. Investment of funds is guided by the following documents: investment strategy, reserve strategy, investment policy, and delegation of authority. National Lotteries Commission invested an amount of 9,591,964,358.40 with various financial institutions for a period of 4 years. The funds were invested as follows. The first investment was for an amount of 5,622,000,000, which was invested between the 23rd of January 2014 to the 20th of March 2015. The second investment was 3,232,000,000, which was invested between the 23rd of June 2015 to the 17th of November 2015. The third investment was an amount of 599 million, which was invested between 17th of August 2016 to the 17th of February 2017. The last investment was an amount of 137 million, which was invested on the 19th of April 2017 and the 4th of May 2017. The SIU requested some documents relating to the above investment, and to this date, we have not been provided with any investment approval documents and or authorization of the above investment by the Minister of Finance. The investigation and financial analysis is also ongoing. Other matters. The SIU and the NLC held a meeting on the 5th of February 2026 and resolved on the following in relation to the new proclamation. Referrals of forensic investigation. The NLC to formally refer the identified 122 forensic investigation project cases that fall within the scope of the proclamation to SIU for further investigation and action where applicable. It was further highlighted that none of the projects that fall within the mandate of the SIU may be outsourced to the NLC forensic investigation panels of services providers, as this could be construed as irregular and wasteful expenditure. Cases with outstanding grant tranches. The NLC to conduct review of the 28 cases falling within the proclamation where grant tranches remain outstanding. The primary investigations will be conducted by in-house forensic investigators. Once completed, the report and supporting documents will be handed over to SIU. LCM supporting documentation, procurement matters. The NLC to reconcile and confirm receipt of all SCM supporting documentation submitted by NLC relating to procurement matters falling within the scope of the proclamation. Review the completeness of the supporting documentation, including bid documents, evaluation and adjudication reports, minutes, contract, variation orders, and payments record where applicable. Reconcile documents for all outstanding supporting documentation and additional information required to enable the SIU to proceed with investigation under the mandate. This process is ongoing. Summary of outcomes. Value of contracts under investigation with potential civil litigation is over 2 billion rand. We haven't calculated all the allegations that we have received so far, more so because of the extension of the proclamation. Currently, we have recovered 9.5 million in cash. This 9.5 stems from this 9.5 stems from the AODs that have been signed with our persons of interest. Preservation orders by AFU. AFU has preserved the properties to the value of 78 million rand. Preservation orders and review application by special tribunal. Currently, we've got matters with the special tribunal to the value of 626 million rand. Value of pensions preserved is 6.8 million rand. Disciplinary referrals, we've got 13. NPA referrals, we've got 19. Administrative referrals, we've got 2. Referrals to professional bodies, we've got 9. Interim report that has been submitted, it's 1. Recoveries of movable and immovable assets. In terms of AFU number 1, they've preserved to the value of 33 million rand. AFU number 2 to the value of 24 million rand. AFU number 3 to the value of 13 million rand. And the last AFU preservation to the value of 6 million rand. So the total amount is 78 million rand, 207,000. That is the preservation by asset forfeiture unit. Recoveries and of movable and immovable assets by special tribunal orders. The total value of all our review applications and preservation orders is that just over 625 million rand. And the total of pensions is 6,877,000 rand. Here are the referrals regarding the referrals to the NPO. So here we just chose some of the people who played critical roles, but because they have not yet been charged, so we didn't mention their name, except in number 19, where we mentioned 18 and 19, where we mentioned Mr. Petra Sidiwe and Mr. Johannes Kosa, because they've already been charged and appearing in court. So the rest, we tried to hide their names because they have not yet been charged. So in terms of the these disciplinary referrals that we have submitted to NLC, we have the first one that we submitted was against Advocate Huma, that we submitted to the then minister. Advocate Huma resigned before the DC. The second one was Mr. Philemon Rasimateli, the former COO. He also resigned. The next one is Mr. Livingstone Marubin Ramatsekisa, former risk officer. He also resigned before the DC. Mr. Sibonelo Vilakazi, client liaison officer in Devon office. He was dismissed by the DC. Majori Litwaba, GA agency chairperson, she retired before the DC. Haubusi Haubakwe, assistant manager in Northern Cape office, she resigned before the DC. Sanele Dlamini, acting COO, he was dismissed by the DC. Hohuntle Matseke, grant agreement assistant in Northern Cape, resigned before the DC. Guguleti Yako, legal manager, she was challenging our DC referral through the courts, but she then resigned sometimes last year. Miss Dora Mwedi, executive secretary, she also resigned before the DC. We await a DC ruling for Miss Tokozile Manju, provincial manager in Free State, and Mavis Mulabu, assistant manager, also in Free State. Other referrals, we have submitted LPC referrals against Mr. Leslie Ramulipo. The hearing was set down beginning of the year last year, but Mr. Ramulipo said he was overseas. When LPC requested travel documents, he then claimed that no, he was hospitalized. So as a result, he won't be able to appear. So we are waiting for LPC to give us another hearing date. We have also submitted DC referral against Advocate Huma and Guguletu Yago. We haven't received hearing dates for these two. We also submitted CIPC referrals against seven directors and 14 companies to the CIPC. We have submitted systemic recommendations to NLC. Based on the findings during investigation, the following recommendations are made. All current proactive funded products should be captured in the grant management system and fusion system, because when we conducted our investigations, we then uncovered that majority of these NPOs that were proactively funded and where there are issues of suffering money out of NLC, they were not captured in these two systems. The system is designed in a manner in which it is able to detect different applications for grant funding from one individuals using NPOs and NPCs. The SIU recommends that the NPC procure an integrated system that is able to detect such abnormalities. Lifestyle audit for all NLC employees, proper project management, establishment of proactive funding project committee, separation of duties between NLC employees and distributing agency members. Court challenge relating to the SIU mandate to investigate the affairs of the NLC. The SIU obtained a preservation order from the special tribunal seizing assets of Prof. Nebutanda, including several immovable properties. Thereafter, Prof. Nebutanda instituted review proceedings in the North Gauteng High Court, Pretoria, seeking the following orders. Decision by the President authorizing an investigation into the affairs of the NLC be reviewed and set aside, as neither the affairs of the NLC nor that of the National Lottery Distribution Trust Fund or that of the distributing agencies falls within the ambit of Section 2.2A to Section 2.2F of the SIU Act, and that further seeking a declaratory order that the SIU and National Director of Public Prosecution, by virtue of number 1 above, may not utilize any of the evidence and documents procured during the investigation and conducted in pursuance of the relevant proclamation, and for all the documents and evidence procured during the SIU investigation under relevant proclamation be returned to the rightful owners. The SIU is opposing the application on the basis that NLC is an organ of state. The NLC is a Schedule 3A public entity that was established in terms of the Lotteries Act number 57 of 1997 to regulate the national lotteries, sports pools, and society lotteries, and to raise funds for worthy causes. The NLC is governed by a board appointed by the executive authority. The executive authority of NLC is the minister in the Department of Trade, Industry, and Competition. So all the pleadings have been closed now. So we are only waiting for the court to set down the matter for hearing. Thank you.
No, thanks, Mashudu. Chair, that's the presentation from SIU. But just to add on, there's a slide where we showed the name of the people. And I think he didn't read the paragraph underneath where we indicated that the names were mentioned because some of these names are already in the public. Some, there are court cases that are ongoing. Some, the disciplinary process is underway where the disciplinary process being outlined outside in the public. So that's why we mentioned the name. So wherever there's the case is not in the public, we make sure that we retain that name. So rest assured that we've covered that. Then with regard to the investigation, you can see that there's quite a number of NPO and NPC that are currently under investigation. And what we have found out of this is that there's so many layers of money flow from the NPO to the different types of members, and whereby after it goes to certain members, there's also many layers from those members. And our role with investigation is to make sure that we trace the money until the last cent. So you'll note that we were supposed to finish last year in December with this investigation, but because of the numerous number of accounts that are involved, where money move from this account to the next account, and every time we need to request the bank statement where it takes long. So that's why it's taking us a little bit longer to finalize some of these other matters, but we are quite on it, Chair, to make sure that we recover all the money that is being taken from NLC. And also from our side, we ensure that we really speed up these matters and we make sure that investigation is done, we move on, we make referral so that action can be taken. We don't wait until the investigation is finalized. Whenever we see any irregularity, we refer immediately so that action can be taken. Otherwise, I think that is all from our side. And let's thank the committee for allowing us to present, and we'll await for any question at the end. Thank you, Chair.
Thank you very much. We will now move to the presentation by NPA, also allocated the same amount of time. Thank you very much.
No, thank you. Thank you, Honorable Chair, honorable members of the Portfolio Committee. Just to do a quick check, Honorable Chair, am I audible?
Yes, you are audible, Advocate.
Thank you. Thank you very much. Our IT was assisting me earlier. So, just really to proceed quickly, I'm joined by my colleagues, Honorable Chair, but the list is quite lengthy. It may take a number of time. Every one of them who comes onto the floor, they will introduce themselves, especially those that will be presenting, which is Advocate Ngebe Kanyani, and then Advocate Marnus Stein from the AFU. Thank you so much, Honorable Chair. I'll ask my colleagues just to share the presentation, please. Please assist with the presentation.
Margot, are you able to assist the advocate, please?
Thank you, Honorable Chair. I was expecting my colleagues to assist as we spoke. There we go. Thank you very much. And please, I will indicate when to move the slides. This is really the contents of presentation. Honorable Chair, will proceed to the next slide. Next slide, please. Right. So, no, slide number 3. Right. Honorable Chair, as the SIU indicated, there was a proclamation that led to all these investigations, as they've outlined in their presentation. I'll go to slide number, bullet point number 4, sorry. Still on slide 3, bullet point number 4. This bullet point, Honorable Chair, really indicates that all the matters that are arising from the SIU referrals are being pursued by serious economic offenses of the DPCI. Why are we saying that? As a result of these referrals, because of some of the statements that needs to be reviewed and some of the processes that needs to be done in terms of the criminal investigations, the matters are referred to the DPCI for that purpose, And once it's done, and we do work with the DPCI, provide prosecutor-guided investigations, it's not that the information referred by SIU or evidentiary material is ignored. It's not ignored, it's been used, and hence, in some instances, it speeds up the further investigations that are required to ensure that some of those statements are prepared in a manner that meets the prosecutorial expectation. So I thought I would explain that part to indicate, and we were hoping that DPCI will be in attendance, but even in their absence, we will be able to indicate where we are, where the matters are. Right. In terms of the mandate, Honorable Chair, I mean, the Honorable Committee would know that the NPA exists for purposes of prosecution in the main, general and specialized prosecutions, as indicated in Bullet 1. Bullet number 2 in the mains indicates that NPA also has the asset forfeiture unit, which ensures that we recover the assets that are acquired corruptly or in any criminal manner. And then, of course, we've got a witness protection program where we protect witnesses that are at risk. Slide number 5, please. Right. So bullet 1 just indicates SIU referral legislative mechanism. Bullet point number 2 really it's what I've indicated, that with the referrals, while they, in terms of the law, in terms of the SIU Act, are referred to NPA, but to now deal with this legal requirements in terms of criminal investigations, we do involve DPCI. And in fact, this started quite a while back, Honorable Chair. So SIU now does almost dual referrals, right? While to NPA and then to DPCI, so that we save time. Now, Honorable Chair, the honorable members could possibly recall that there was quite a significant change in the criminal justice system a while back when the DSO, Directorate for Specialized Offences, was disestablished, and the Hawks sort of came up. These referrals to NPA, at the time, it was sort of legally convenient because the DSO could receive and also investigate at the same time. So when it was disestablished, the legislation did not change, and that we are of the view that created, this legislative impasse that we find ourselves in, where matters have to be referred to NPA and then to DPCI at the same time. But Chair, we did not just leave it there. I'm aware that SIU is busy with the legislative amendments, but in the main one is the National Anti-Corruption Advisory Council that also dealt with this aspect in their recommendation. So we're looking forward that when the legislation is introduced to implement the advisory council's recommendations to the president, this aspect will be dealt with. There will really no longer be, this disintegrated approach of dual referrals. But in the meantime, we're doing as best as we can. We do have a memorandum of understanding between the three of us, which is SIU, NPA, and DPCI. So we are working together to ensure that we save time, because we are aware that consequence management is required in the sense of criminal prosecution in this space. And Chair, you will see that a number of matters that we are going to be presenting are showing progress. I've engaged with the team at NPA. We will be engaging with the DPCI just to ensure that we monitor these matters so that they are progressed to prosecution ultimately. But we are also happy that the AFU, which will present later, as SIU has indicated, is also at work in ensuring that we recover these assets while there's investigation that will lead to prosecution. I will pause here at this stage, Honorable Chair and Honorable Members, and hand over to my colleague, Advocate Kanyani, who will take us through the progress of the referrals. She is the Special Director of Public Prosecutions in the Specialized Commercial Crimes Unit of NPA. Thank you very much. My colleague, you can take over from here.
Thank you, NDPP. Good morning to the Chair of the Portfolio Committee and all the members. Good morning also to my colleagues at SIU. The NDPP has already introduced me, so I'll just go straight into it. In terms of the referrals that we have, the total number of referrals that we have from the SIU, we've got 16. And this is because some of the matters related to the same NPO, and so they were then included into one docket and investigated as such. And in total, we've got 14 matters that are under investigation, and we have 2 that are in court that I'll speak of later. We have not declined any referrals relating to the National Lotteries Commission. None of the matters were closed on the merits, but as I said, were included in the main docket, which is the one on top here, the Denzel Primary Care NPO. These are the matters that we have under investigation, and the relevant NPOs are also put in there. We can go on, and then I'll go into more details in terms of the individual matters. The first one, as I said, it includes quite a few number of dockets that are included under this one. Is one of our main dockets. It's still under investigation. A significant progress has been made in terms of the investigation, and there's quite a significant amount of bank accounts that had to be obtained and analyzed, and also get the contra details for that, to be able to see who received the money and how the money was used. What is mainly outstanding in terms of this investigation is to then look at all of these bank statements that were received and do a complete cash flow, so that all the ultimate beneficiaries are accounted for, and we can say how the money was used. Also to then, there's a few other witness statements that are outstanding. The main issue that is outstanding also is then the appointment of forensic accountant investigator to be able to pull all of the information through and write up a forensic accounting report. In terms of the second one, is a Zip Simanzi NPC. Also, it's same information. It's under investigation. There's a few witness statements that is outstanding, and also then to get the forensic accountant report. The third one is a Life for Impact in the 21st Century NPO. Also here, the investigations are quite in an advanced stage, and we've obtained in total, the police have obtained in total 22 witness affidavits, and also the 236 statements, the bank statements that are required to have the money flows. In this matter as well, we require the appointment of forensic accountant and investigator, and to also complete all the other bank statements that are required. The fourth one is I am made for God's glory. It's an NPO. Also with this one, it's under investigation. 13 witness statements have already been obtained to date, and 8 236 statements, affidavits from the bank has been obtained. We also need a forensic investigation to be appointed to do the forensic investigation. The fifth one is the Inkaba Yokulinda NPO. In this matter also is under investigation. We've obtained 13 witness statements, or the police have obtained that. And we've also obtained the accompanying bank statements, and we also need the appointment of forensic accountant. The sixth one is a Tirani Sebenzani Support Group NPO. Same as well. We need affidavits, including affidavits from the NLC, and also we couldn't find, that funds were paid into the identified bank account of Tirani. So there still needs to be investigation in terms of obtaining to see where the money actually went. The seventh one is Veboom Youth Development NPO. Also, as well, we've obtained the police have obtained 12 witness statements, and we still require the appointment of a forensic accountant, and some witnesses that we've identified, we still need statements from them, and some bank statements and contract accounts were identified, so we need to subpoena those contract accounts and be able to do a money flow. The eighth one, Uprising Youth Development, is also under investigation. 13 witness statements have already been obtained, and the significant amount of bank statements that have already been obtained, 45 in total, were already subpoenaed and are being analyzed. We identified that there is still others that needs to be subpoenaed to get the contra. The approximate amount there of the contra account payments that we're seeing is over 5 million. So we see that in these cases, there's quite a lot of bank statements. So there's a lot of movement of money. And so we require to, once we get to see where the money has went, to then find the contract accounts and do further investigations on those. Yani? The ninth one is Zipsy Fusion NPC. It's also under investigation. 5 witness statements have been obtained, and we've received 2 bank statements, and we still need some affidavits from identified witnesses, and then also, like with other cases, the appointment of a forensic accountant. The 10th one, Simba Community Development NPO, same as well under investigation. We've obtained to date 12 witness statements, and then we still require, if we've obtained also 5 Section 236 statements, and we still require 1 more, and some witnesses, including witnesses from the NLC, and also, like with the other cases, the appointment of the forensic accountant. The 11th one, Daun Cultural Music and Arts NPO. We've received quite a significant amount of statements have already been obtained, 36 in total, and also a significant amount of bank statements have already been obtained and analyzed, and we need to still subpoena 7 more and get witnesses' statements, including witnesses from the NLC, and also, like with the other cases, the appointment of a forensic accountant. With Lulamisa, this was a more recent referral. It still needs to guide the investigation and in terms of what should be done. So this is still in one of the newer matters that we've received. And as I explained, there's 2 matters that are in court. One of the cases, I think my colleague from the SIU also touched on it. We named this accused because these 2 are in court, and the matter is already postponed for trial to the 2nd of June. The accused operated a scam where they applied a falsified application to the NLC under the pretense that they were committee members of the NPO. The 2 accused are facing charges of fraud and money laundering. The next one was also, so both of them are in Kimberley. This one also, it is the Hesekwa Caring Network NPC. it also alleged that the monies, the application that was made, the money that was received from the application was not used for the purpose for which the proposal was made for. We've got 4 accused in court, including the NPC. In terms of the charges, the way all the matters that have been referred in terms of the Proclamation 32 of 2020 are dealt with as one matter, because when the evidence was being looked at, it was clear from when the matters were referred and as the investigation progressed that a pattern of racketeering could be seen, and so it is the.
I'm fine.
Is someone speaking?
Yes.
Chair. Okay. All right.
Apologies, ma'am. Can we request that we put our phones on silence, please, because we're disturbing the presenter now. Please, colleagues. And can you just mute everyone except the presenter, please? Apologies for that, madam.
Will do, Chair.
Yes. So as I was explaining that, and I know perhaps the temptation would be to say, why are we not enrolling the matters quickly? It is because as the evidence progresses, it is seen that there are, the same people who were involved in the scam, the same characters, same people, the same pattern. And so it is the plan of the NPA that in terms of the main charges that we would be possibly preferring the charges of racketeering in terms of poker. And so this is why we require that, the entire investigation is complete. We have the benefit of a forensic investigation. All the money flows are shown in terms of, the people who benefited. And so it is the plan that we're going to be charging for racketeering and of course corruption and also money laundering. So these are in terms of the main actors. However, if you go in terms of the other NLC officials, there could also be charges, standalone charges where we don't include them in the big racketeering charges. So there could still be cases where we just charge for straightforward fraud and corruption in terms of PRECA and money laundering. And we're also considering some statutory offenses in terms of the National Lotteries Act. And so we're looking at it in both ways, where we would have the common denominators could be charged for offense of racketeering, which has its own advantages. And then in some cases, we could have individual people who are just charged perhaps just straight for corruption or money laundering. I'm going to then hand over to my colleague in the asset forfeiture unit, Marina Steyn, to speak to the part relating to the asset forfeiture. Thank you, Chair.
Thank you. Good morning, Honorable Chair. Am I audible?
Yes, you are, sir. You can proceed.
Thank you. Good morning, Honorable Chair and honorable members of the committee, our National Director, Acting Head of the SIU, and my fellow colleagues. As Mr. Legeto earlier said, and the ADPP confirmed, the asset forfeiture is indeed on board. We are closely working with the SIU as well as our colleagues in the Specialized Commercial Crime Unit, and we will proceed with whichever matters are ready to proceed on. We received 4 referrals. We have obtained preservation orders in these 4 matters, as is shown there in the values on this presentation. The matters were heavily litigated, and we have been challenged every step that we have taken. If we can perhaps move to the second slide. The freezing orders that we have obtained, like I said, is in respect of four matters. We probably, if one looks at the time that it typically takes to obtain a Chapter 6 preservation and forfeiture, Chapter 6 of the Prevention of Organised Crime Act, that is, we should really have been had some orders in place. However, as I said, the matters are heavily disputed. They, in the course of our bringing the applications, launched several interlocutory applications. The next slide, we can talk quickly about that. I am not going to take up a lot of time, other than to say that they were challenging trying to have property excluded from our preservation orders. They were challenging alleged missteps taken by us in terms of Rule 30 of the Uniform Rules of Court, all of which were successfully opposed. They also tried us to compel the asset forfeiture to submit information completely irrelevant to the application, was also opposed. Application for reconsideration was also opposed. There are also other further steps, but it takes a lot of time. The real reason why we have reached an impasse, Honourable Chair, is the fact that was earlier said, Professor Nevutanda has brought this application against the proclamation that was issued by the President to the SIU. Now, all of the matters that we have proceeded with to date were direct referrals from the SIU, and so in the course of the application, it was placed on record that they have brought this application against the proclamation, and even while the asset forfeiture unit was desirous of continuing, the judge granted a postponement sine die. In other words, it was postponed to an undetermined date, pending the outcome of the application against the proclamation that the SIU is dealing with. At this stage, we are left waiting in the wings, and we will have to wait and see what happens in that application before we can proceed any further. The fourth application is we're still fighting some of the interlocutory applications, and there was the judge in that matter granted the respondents an opportunity to file additional affidavits in the matter, in the applications they are bringing. They have not filed that yet, so we are going to re-enroll this matter to at least drive it to a head where we get to a point where we still then also need to wait for the outcome of the application against the proclamation. So if we can move to the next slide. In addition to what's happened there, and as I said earlier, we are closely involved in the investigations, and as the criminal investigations mature, we will proceed with whatever applications where we can find assets. So that might also mean Chapter 5 or conviction-based confiscation applications, Chapter 5 of the Prevention of Organised Crime Act. In other words, where an accused on conviction, we then ask the court to do an inquiry as to the benefit that the accused enjoyed, and then we will bring an application to confiscate that benefit. And in the meantime, the biggest challenge is we need to wait for the finalization of this is actually, these are not really my slides, but the challenge is really that we have to wait for that application to be finalized. I can quickly mention, obviously, we have seen this as a golden thread, that the appointment of forensic firms to do financial analysis is always a challenge. This is happening with the engagement of the DPCI, typically because the DPCI is running with the investigation. They would then appoint forensic auditors where required. That sometimes takes long, but we are taking steps to ensure that that is happening quickly. The legal challenge on the proclamation, we've mentioned that. And then another challenge that we've seen is that certain of the individuals implicated within the NLC are still employed. The problem there obviously is the risk of interfering with evidence and reputational, to mention but two. So that really concludes my presentation on the asset forfeiture aspect thereof, Chair, and I would be happy to take any questions.
Thank you, Marnus, can you please go to slide 31? Honorable Chair, as we proceed to slide 31, we thought it appropriate to mention these challenges, but they are not insurmountable. We are collaborating with SIU, DPCI, all in the interest of ensuring that these matters should progress to prosecution ultimately. The concluding remarks, Honorable Chair, is really just to assure the committee that we will continue to ensure that matters referred receive attention. And the collaboration and the engagements between the agencies should proceed as envisaged by the MOU so that the matters can proceed. Yeah, my colleagues indicated, this, interlocutory applications that are brought by the parties and so on. Of course, the parties will use every legal, provision available to them. But as the NPA, we are awake to that, and our prosecutors are trained to ensure that they stand up and meet the interlocutory applications. The appointment of forensic firms have been mentioned by my colleague. We will obviously work with the DPCI to ensure that those appointments of forensic investigators are made. The collaboration with SIU as well, where they may have made some of the analysis of the money flows. So all of these efforts should converge into one result of ensuring consequence management, either from a civil point of view, which is asset forfeiture, or from the prosecution perspective. Honorable Chair, that was slide number 31, and it is the concluding slide. Please slide on to make sure I'm not leaving any slide out. Slide 31 was the last one. The next one is really to thank the committee for the opportunity for us to present. As I indicated, we are showing some progress, but we will monitor closely in terms of ensuring significant execution. The next occasion we appear, we should show a really significant traction. I should earlier on have acknowledged my colleague, the acting head of SIU. Thank you for the collaboration and the working together of the two teams. Thank you, Honorable Chair. Thank you.
Thank you very much, Advocate and the team. We are now ready to engage with the presentation. Andre, you'll assist me with the hands.
No problem, Chair. Mr. Thring, Chair.
Yes, Honorable Thring, you'll be the first.
Mr. Chance.
Member Chance.
Ms. Motsikatsi.
Ms. Motsikatsi. Yes.
Those are the current. And Ms. Schlazer-Webster, Chair.
Yes, there are 4 hands, please, in that order.
Thank you, Chair. Chair, let me firstly thank the SIU for the great work done in uncovering the scale of corruption in the NLC, as well also to the NPA for the work done and the presentation that was given to the committee. But Chair, I think just as an introductory remark, we must remember that the corruption and looting that we are seeing in the NLC was uncovered during the 6th administration. So it's about 5 or so years in the making, so to speak. And it was uncovered when the members of the portfolio committee in the DTIC in the 6th administration, we pressed for an investigation into the NLC when members of the portfolio committee asked questions with regards to press for an investigation into the NLC. And the board members, including Professor Nevutanda, refused to provide details of the recipients of funds from the NLC particularly with the use of the proactive funding provision. So this raised suspicions within the portfolio committee. And so in this regard, Chair, I want to support the SIU's recommendation of a interactive system to prevent one person from applying for NLC funds using numerous bogus NPOs or NPCs, including, Chair, the establishment of a proactive funding project committee. I think that there was some concern about whether the proactive funding model should actually, or provision, should actually continue to exist when one looks at the abuse that this proactive funding provision and the abuse that actually came from it, where the board is able to identify projects themselves without going through the requisite processes. Chair, so also in the sixth administration, we had reports from the SIU on the progress of the investigations. In terms of my remembrance, we were presented with there were three stages. 2 stages of the investigation had been completed, and I think the first 2 stages there was some corruption, maladministration, looting, and so on, to the tune of some like 500 million rand. That was in the first 2 stages. The last stage, stage 3, was some 900 million rand. That took the total of the investigations in terms of monies that were alleged to be looted and gotten through malfeasance to about 1.4 billion rand. Now that was already in the sixth administration. So my concern here, Chair, is that after some 4 to 5 years of the uncovering of this corruption, this lag in terms of time in the conclusion of prosecutions, it gives those who have been alleged to be found guilty of fraud, corruption, and so on, it gives them opportunity to provide Stalingrad-like tactics, much like Professor Nevatanda is actually doing with his contesting the case against him. It also gives the guilty time to disappear or to relocate, like Prophet Bushiri. And also, Chair, my concern is that you may actually lose witnesses along the way, either through ill health or not being able to find them if they relocate. And so these are some of the challenges in terms of the length of time. And I think that the committee needs to understand that we have to, as in terms of the mandate that we have, with the oversight that we have over the department and its entities, we have to exercise our mandate to ensure that these cases are able to proceed speedily. Because 4 to 5 years, and we are still in the investigation stage. We still haven't seen the necessary prosecutions, with some 1.4 billion rand identified by the SIU, and then there's still the 9 billion rand of funds that have been invested, and the SIU also still waiting for whether it's from the NLC, because of delays and the refusal, apparently what appears to me, to hand over approval documents for monies that have been invested by the NLC. Now, Chair, I'd like to know also, just on that 9 billion rand, if the SIU could indicate what is the status of the SIU receiving these documents, because there's 9 billion besides the 1.4 billion rand or so that has been identified. There's 9 billion rand that has been invested by the NLC, and what is the status in terms of receiving those documents, the investment approval documents? What is the current status on that, and where is the holdup? Then I think also, Chair, to the NLC, to the SIU, the NLC board members who resigned or retired before the disciplinary committees were held. I think it's important that these members these officials must be relentlessly pursued and prosecuted where evidence leads to such prosecution. They cannot be let off the hook simply because of a resignation or retirement, where obviously evidence leads to their prosecution. And then my last question to the SIU is, what is the response from the CIPC for the delinquent directors to be barred from registering new companies? And then, Chair, in conclusion to the NPA, so working together with the SIU and the DPCI, this is what you've indicated to save time, but 5 years have passed with no prosecutions. So what is you have identified some of the challenges, and I'm going to be raising obviously that the forensic accountant specialists and some forensic companies and the procurement of those forensic companies seems to be one of the challenges. But why is it taking so long? Almost 5 years have passed, and we are not seeing these prosecutions. And then why is it also taken so long to obtain the assistance of a forensic accountant company? Because if one looks at the cases that you presented, I think the 12 cases, this is with the majority of those cases. Some of the delays is the procurement of a forensic accounting company. In cases 11 and 12, the witness statements and documents from the NLC are awaited. You're still waiting for those in terms of your outstanding investigations. Now, the NLC should be the first to provide those statements and documents speedily, particularly with the new board that we now have, with some members there who understand good governance, because the new board members have been around for a while, and so there should not be any outstanding documents in terms of witness statements and documents required by the NPA. Then, Chair, the NPA obviously must work closely with SAPS in the prosecution of cases. Now, in the light of the Matlanga Commission, the corruption uncovered in SAPS, are there concerns by the NPA about any cases being jeopardized because of SAPS's failures to play their part in these investigations and the role that they have to play in ensuring that we actually get prosecutions where individuals are found guilty? And then lastly, Chair, the NLC employees implicated in corruption and who are still in the employment of the NLC. I agree with the NPA that these particular individuals must be suspended pending the outcome of investigations. This portfolio committee must insist that these employees are actually conflicted, and they may indeed hinder progress of investigations, and as such, that these particular employees who have been implicated in corruption must be suspended. Thank you, Chair.
It was Mr. Chance, Ms. Motsakatsi, and Ms. Schlazer-Webster.
Yes, in that order.
Thank you.
Andre. I don't want to disturb them.
Thank you, Andre. Thank you, Chair, and thank you to the presenters this morning. The first question actually is a procedural one, Andre and Chairperson, and that is that this meeting has only been added to the Z list today, as I understand it. That is very irregular. And is that possibly one of the reasons why you weren't able to get the SAPS and the DPCI to the meeting? It's very, very disappointing that we don't have either of those, not to mention the NLC itself, coming to the meeting. And I can't understand why it's taken so long. We had this on the program for weeks, and it doesn't appear on the Z list. So perhaps we can get an answer on that point later on. But as the members will recall, we last had a presentation on this subject on the 21st of November, 2024, which is 16 months ago. And I have to say that I'm very disappointed that the progress that has been made since then is very little, actually. There may have been some work going on in the background, but in terms of actual prosecutions, virtually nothing has taken place. And I recall Advocate Matibi, who at that stage was the SIU head, said that he was offering to second investigators to the SABS and the Hawks, and the MOU was signed. I think it was included in the APP of 2023-24, and the MOU was signed. But it's a long, long time, as Mr. Thring has indicated. Since then, it just seems to me that everything is going at a snail's pace. And I want to get the assurance. He has given the assurance, but I just don't see that it is evident in the actions that we are seeing, or the inactions that we are seeing from Advocate Matibi, that things are actually moving ahead at the required pace, as was recorded in the presentation earlier. Many of the individuals are maybe disappearing, or the evidence is being played around with, is not being presented, and it does present a huge problem. And I think that what is evident from this is that it's referred to as money laundering, but it's not even money laundering. It's just blatant theft. I mean, it's clear that these individuals had found a massive taproot of funds, which became an easy source of money, and they didn't even bother to hide their tracks, really. And the appointment of these forensic accountants is absolutely vital. And I again refer to Mr. Thring's comment. Why has it taken so long to appoint this company? And is it possible for one company to handle all of these cases, bearing in mind the intricate nature of these transactions? It will be very interesting to know, as soon as that company is appointed, the identity of that company and the resources that it has at its disposal. And I'd like to know from Advocate Matibi, how many prosecutors have actually been assigned to this case? Because the complexity of these cases means that one or two prosecutors simply won't be able to handle it. I'd like to know how many actual warm bodies have been assigned to this case. I also want to draw the attention of the committee and those present today that we're dealing with individuals whose lives have been ruined in this instance. And I just draw attention to Denzi Primary Care that was set up by Mr. Addo Kricker, who died just recently. And this money of 27 million rand that had been allocated to his primary care center, only 6 million rand was used, the rest was looted, and he was subjected to the most appalling legal abuse, really, by the NLC, by Mr. Ramalifo, by Mr. Latwaba. And I'm sure that had a lot to do with his demise. And then we have the case of Mzukisi Makatsi. And the NLC is revealed in the answer to a question that I put last year, spent 9 million rand on legal fees to attack this gentleman. And he is a whistleblower that is now basically gagged because of the NDA that he signed with the NLC from exposing what has actually happened. And it really does indicate that what's been going on in the background is just a massive miscarriage of justice. And I think that the continuing lack of justice that we are waiting to see in regard to these prosecutions is just prolonging the agony of the victims. The point that Mr. Thring also mentioned, the investment funds, do we know where that money has been invested? There's vast amounts of money over 4 years. And what are there any returns from that money? Where are the returns being reflected? Are they on the NLC's balance sheet? It would be interesting to know where that money is actually sitting, because that's a substantial sum of money, and the interest alone would be enough to fund vast numbers of grants. I'd like to know what is required beyond the accountant's forensic work for charges to be laid and enrolled. The point was made by Advocate Kanyani that racketeering charges are more complicated, but I'm not sure that the sentences which would be laid down for the people found guilty would be that different. Surely it would just be important to get some of these people into court and charged and found guilty. I'd like to know what is the length of time between where we see these cases being prepared and when they will actually end up in court? And then, yes, the other point is that the Stalingrad tactics that are being used is clearly because of the fact that the accused have virtually unlimited funds to defend themselves. And I'd like to know what sort of money are we talking about? How much is being budgeted? How much is the NPA and the SIU going to have to spend of state resources, taxpayers' money, to actually seek justice for these people? Because this is money which really could be better spent. But I suppose the money just has to be spent. But I'd like to know what is being spent by each institution. I think that's all for now. Thank you, Chair.
Good morning, Chairperson, honorable members, and all in the meeting. Chair, I've got only 2 questions. It's related to the presentation of the ICU. In terms of the presentation, I also want to ask a question in terms of the investments. I just want to know that is there any legislation that is authorizing the NLC to invest funds instead of transferring funds to community members of applications that will be coming in? And then my second question will be, in terms of the outstanding grants that has not yet been transferred to people who might have been applied, is there any mechanism in place to ensure that when funds are transferred to people, it's to the right people or to the right community members? In terms of the NLC chair, the report indicated it means that when community members are applying to the NLC, their projects are being hijacked, and then the members and the officials in the NLC are using those applications to enrich themselves. And I also just need to say that I appreciate the work that the SIU has been doing to ensure that they investigate these cases and ensure that these cases are going to court so that people can be held accountable to ensure that we do our work in the right way. Chair, I think it will be only those 2 questions. Thank you.
Member Webster.
Thank you very much, Chair, and thank you to the SIU and the NPA for the presentations. My first question is around, systemic issues, because listening to these presentations, particularly the SIU presentation, it's very clear that there was a system that was set up, or at least enabled, for the scale of corruption that took place to actually take place. I think the SIU referred to it as saying that the system was not geared to detect abuse. But what's very clear is that there were failures in monitoring, there were failures in auditing, there were failures even in managing some of the projects. Now, the truth is that the board and the executive are actually legally required to make sure that they maintain effective systems, that they maintain an efficient system of financial control, and are preventing that irregular or wasteful expenditure. So my question really is around whether there are specific officials that are being held accountable for the systemic failure. What action is being taken to pursue, whether it's financial misconduct charges or civil recovery against them specifically for that. Even in cases where direct criminal intent may not be easy to prove, but being held accountable for the systemic failure. And I believe that is possible through financial misconduct charges, and even through civil recovery. The second question is related, and it relates to findings that clearly show manipulation of financial statements, particularly with regards to the NPO, and the role of individuals that weren't even registered to enable those fraudulent applications through those NPO structures. So I noticed that in the NPA presentation, there's referrals to fraud and corruption cases, etc. But I want to know if there were any specific referrals that are explicitly around issues of those fraudulent financial statements, because that means there were professionals who were enablers and who may be continuing to operate in other institutions, enabling the same kind of corruption. If you're not holding professionals who are enabling this kind of corruption, then it means that there'll be repeat exploitation in other systems, maybe even in the same system, in the NLC itself. And then the last question is about blacklisting. If there's any referrals that are being made to whether it's Treasury, whether it is even through DTIC to CIPC, to other regulatory bodies, to ensure that there's individuals that are actually not able to continue operating, particularly within the public sector, or benefiting from public funds. Have we reached that point? And is there any sort of process that then sends or refers for blacklisting or action through regulatory bodies and even through some of the other departments like Treasury? Thank you.
No, thank you very much. Andre, if you can just come in and clarify the Z-list question.
Shall I do it before or after the last two members speak, Chair? Mr. Langa and Mr. Mlubi?
Oh, I didn't see their hands. Okay. So
Yeah.
after they're done, okay. Member
No problem.
Langa and Member Mdluli. Apologies for that.
No, thank you very much, Chair. I think I've been covered by Honorable Tring and Honorable Chance. Thank you, Chair.
Thank you, Member Mdluli.
Thanks, Chair. I've also been covered, Chair. I indicated it in the message box. Thanks.
Thank you. Over to you, Andre.
Chair, we just the rationale for it only being on the Z list yesterday. Chair, we're waiting for confirmation from the SABS and DPCI. Hence, we only got confirmation. We couldn't get hold of them. As you remember, we were on oversight last week, Chair. And once we hence the late referral, because we thought, given the importance of SABS as part of this process, the meeting may be postponed. Hence, we delayed the notification on the Z list. There was no other rationale for that, Chair. It was on the committee's program, but once we confirmed that SABS will not attend, we put it on the Z list, Chair, just with NPA and SIU on the Z list, excluding SABS, Chair. That was the rationale and thinking behind why did we delay putting it on the Z list, Chair. Thanks.
No, thank you very much.
Can I just ask a follow-up on that? May I ask just a quick follow-up?
No, Andre. Sorry, Member Chance, can you just wait? Just note your question because we want to make sure that we have sufficient responses on the other side. I just wanted to add, I think colleagues have asked questions. I wanted to ask that we get a sense of the timelines. Member Chance indicated that we last met 16 months ago. What are the timelines for the team, for all the teams to wrap up this project? Firstly, secondly, at the level of SIU, what are the costs associated with these investigations to date, so that you can see between that which is being recovered and that which is being paid to SIU, what are the numbers there? I want to allow you to come in, and then Member Chance, as soon as they're done, you'll come in because you are asking a procedural issue. I think you're not asking the SIU and NPA. Thank you very much. Over to you, SIU, and then followed by NPA.
No, thank you, Honorable Chair. I will answer some question, and my colleague will also answer other question. But I'll start with the one where it says the board member who resigned before the DC, whether are we pursuing them? I'll just indicate that we do pursue them, Chair, those who resign, and it is for them, it's unlike official. Normally when it's official, we make sure that we freeze their pension so that we can able to quantify their liability in terms of causing any irregularity into the to the department. But on the board members, when they resign, we follow them up. Some of them, we refer them to their regulatory bodies. For example, lawyers, we do that. And also we refer some of them, actually all of them who are misconducted, to the CIPC so that they can start with the delinquent process. So we don't leave them. The fact that you resign doesn't mean that it absolves you from any liability that we might have you have caused to the NLC. Then the other one talks about the budget for the cases, but this one I know it's coupled up with what the Honorable Chair has asked as to how much we have spent to date on this investigation. That one we'll try and get the number, and if we're unable to do it, we can always send it. But with regard to the cases, remember, investigation is done by SIU members, so the expenditure mostly come from the council that we are appointing, and the expenditure with regard to that, the council depend whether there are those interlocutory application where members just prolong. The more they prolong the litigation, the more the expenditure goes up. But that's why we make sure that we freeze their money so that they don't use that same money in order to fight us. So that's the mechanism that you have put in place. So the other question was whether do we help people that cause the systemic failure? Whether is there any recourse for them? So we do. We don't leave them. If you will have seen in the presentation, there are systemic recommendations that we have made, whereby some of this systemic we have identified, those are the things that led to the failure in terms of governance. Then in the presentation, we have mentioned some of those people who have led to those failures. And some of them resign, some of them we have freeze their pension. So we're not letting anybody to go scot-free. That's why investigation goes to the bottom to say, what is it that happened and what could have caused this thing? That's why from our side, Chair, we really emphasize the issue of prevention, because we know that fighting corruption is very, very expensive. But maybe if we can start pushing the prevention part, it will really help in terms of mitigating the high cost of fighting corruption. So that's why we really want to identify those systemic issues so that they are addressed and the same problem doesn't continue over and over again. Then the other question was whether did we make referrals to professional bodies regarding the enablers. Those enablers, like the forensic accountant who help with the financial, as the member indicated, the SIU member indicated that some of them are not registered with any professional bodies. So they are on their own. But as we have indicated, IRBA indicated that we must still refer them to them, because the fact that they are professional, and even though they are not listed with them, they will able to take action, because at some stage they might want to apply to be a member of either IRBA or any other association. So therefore the referral will find them there. But they are also held liable. It doesn't absolve them from any criminality referrals. The fact that they are not part of any professional bodies will still refer them for criminality if what they did has caused any harm to the state. So that's what we do. And with regard to the cost, like I said, we will find the cost and the issue of the timeline of investigation. We have indicated the end date as 27 2027 March, where we envisage that they should. And it should be noted, Chair, that we have identified further 600 NPO and NPC that require further investigation. The problem is if there's any referrals that comes in and it's covered by the proclamation, we are enjoined to make sure that we investigate. So we can't say we are finished, we can't look at it. If it's covered and it's within the mandate, we're gonna do it. But based on what we have scheduled that by the end of March 2027, we should be done with all the investigation. So that is it. Then I'll hand over to my colleague so that he can answer other questions pertaining to the investment and others. Mashudu, over to you.
Thanks, Chair and HOU. When it comes to the non-billion investment of funds, so the funds were invested with various normal banks that we know, the big five, if you can call them. Like, for example, the first 5 billion was split into different banks. It was 84 million was invested with Nedbank, 168 million was invested with Rand Merchant, 148 million was invested with ABSA, 101 with Nedbank again. So just like that. So the entire 9 billion was invested with the normal banks and some couple of million with PIC. So when it comes to the documents that we requested from NLC and received, so we received a lot of documents regarding this investment, but the only documents that we didn't receive is with regard with the processes that they are supposed to follow before they invest, because there must be the approvals. So, but in terms of our preliminary findings, it looks like those documents don't exist. They are not there. So that's why we didn't want to mention that perhaps those documents are not there, because maybe someone in future might make those documents available to us. But at this moment, we don't have those documents. We communicated with the current executive of NLC. It looks like those documents are not there because they've given us everything regarding this investment of funds. There was a matter that was just discussed in jest regarding the likes of Muzikisi Makate. So this is the guy that we interviewed when we started with this investigation. He was an employee of NLC at the East London office. So what happened with him is that he was requested to approve certain application, even though that application was submitted in her office or in Pretoria. But Ms. Mampani wanted him to approve that application. But he then said, no, he can't approve that application because it was not, he is not the one who received the documents and processed it. Whoever received the application and processed in Gauteng is the one who's supposed to approve that application. Because of that refusal, he was then taken to the DC and dismissed. When we conducted that investigation of the very same matter that he refused to approve, we then uncovered that Ms. Mampane, who was the commissioner at the time, received just over 200,000 from the very same project. Another question was about the policy. I think I've answered to say, yes, indeed, there's a policy that allows NLC to invest the funds, but there are guidelines as to how the funds are supposed to be invested. But at this moment, we don't have any proof that the guidelines were followed or the policy was followed, and also that the approval from National Treasury was requested and given. But we have requested National Treasury to confirm to us. We are still waiting for their response. The issue regarding the professional companies that assisted the NPOs to submit fraudulent applications. Yeah, we have submitted referrals to the professional bodies. Others return back to say the companies that we spoke about are not their members. But they then said, even if the companies are not registered with their bodies, they are still going to discipline the individuals. So there are a couple of chartered accountants who we are communicating with these professional bodies who are ready to discipline them. In terms of CIPC, we have submitted, I think, 7 referrals to CIPC. They communicated back to us to say that they must follow their own internal processes, investigation, and that they are going to hire a senior counsel who will handle our referrals. Thereafter, they will go to court, to the High Court, to declare them the delinquent directors. So we are waiting for CIPC to finalize their own internal investigation, but we are ready to assist them. I think these are the only questions because the rest of the questions were answered by the HOU.
Thank you, Chair. Back to you.
Honorable
Thank you,
Chair.
NPA.
Thank you, Honorable Chair, if we may. My colleague, Advocate Kanyane, will also come in on some of the procedural matters. But Chair, we do acknowledge upfront that the matters are seemingly taking unreasonably long. So there has been quite a lengthy investigation by the DPCI or SAPS, because the investigations are done, or these further investigations required by NPA are done by the SAPS. We do work with them to provide guidance, prosecutor guided, but we really depend on them. And in our collaboration, we really monitor this progress. But the issue of capacity comes to the fore. So again, as I indicated, Honorable Chair, and we're not making any excuses or passing blame. We will have to engage with the DPCI to find out, where are the bottlenecks, in particular around the appointment of forensic firms that are required, because the appointments are done on their part, on the part of SAPS DPCI. So the process to appoint is done in terms of the procurement process of the police. So we'll really have to re-engage with them and find out, what are the bottlenecks, because I've just really looked at some of the matters. Yes, indeed, they date quite a number of years back. So there is really no substantive excuse that we can really put forward, except to say there are those matters, even though it's only 2 of them shown on slide 16 and 17. There are those matters that are already in court, and they've been the investigations in those matters are complete, and the matters have been postponed for trial. So we look forward to the trial commencing and ensuring that we bring out a successful prosecution. Are we concerned about SAPS, DPCI, given the Madlanga revelations? We do work closely with the SAPS, and from where we sit, and being involved in providing prosecutor-guided investigations, our involvement entails also monitoring the progress of those cases. So wherever there's unreasonable delay, we need to point it out wherever we observe any prejudice to the case, we need to point it out and ensure that it's attended to. So we will ensure that that continues in that sense, so that there can be those checks and balances. In terms of the Stalingrad tactics, yes, as I indicated, we have pointed it out even to our prosecutors that this has become one of the strategic focus areas of NPA, to ensure that we skill our prosecutors such that they can stand up and challenge the Stalingrad tactics. And we are really satisfied that the courts are gradually coming to the party in terms of keeping the other parties, the accused party, to account where there is deliberate delaying tactics. So in terms of the monies that are expended in the investigations, I think the questions was raised for both SIU and NPA. Chair, we don't have those amounts at hand at the moment. We can really work with our colleagues to try our best to compute, but the criminal prosecutions involves quite a number of parties. It involves the police efforts, it involves the prosecution's efforts. So to quantify that is going to really require the police and NPA, but we will really do our best to see how we quantify that, and then we can provide that to the committee. How many prosecutors have been allocated? I'm sure my colleague will respond to that in terms of the sufficiency of prosecutor guided. I was informed that the prosecutor guided effort is at a sufficient level at the moment, but of course she and the team will continue to monitor that space. Why is it taking long to appoint forensic investigators? As I indicated, the appointment is done by DPCI, but we will really continue to call them on to ensure that process is speeded up. Chair, at this stage, I would like to hand over to my colleague, who can then respond to some of those questions. Thank you.
Thank you, NDPP. I think you did cover most of the questions that were asked. A lot of the members' questions were around, the time it's taking to finalize investigations and the appointment of the forensic audit firms. That is our biggest challenge, and from our side, we have really engaged the DPCI to get this done. We have at this moment undertakings that by April we will have a firm appointed. There was a firm that was identified almost a year ago, but because of internal SCM issues at DPCI, that appointment lagged and did not finalize. We have now undertakings from them that by April it would be done, and we're hoping that that will be so. It is not ideal to have different firms appointed because of the nature of the case. If you do that, then you run the risk of having them duplicating and not getting the benefit of seeing the full picture. There are also questions regarding, what else do we require to make a decision? The simple answer to that is that whilst we guide the investigation, we sit down, we have a case plan, and we plan what evidence we need with the police. It still remains ultimately the police responsibility to carry out the investigations, and only once the investigations are complete in terms of what has been agreed on and what we require in order to get a conviction, are we then able to make a decision? So we are really reliant on the police in terms of that. The advantage of pursuing racketeering charges is that indeed there is a benefit in terms of ultimately in terms of the sentence, because you can get as high as a life imprisonment or a billion rand fine. But there's other advantages in terms of the sort of evidence you can bring in and what can be admitted during a trial of that nature, as opposed to when you're prosecuting people for individual charges like corruption and money laundering. So there is a strategic advantage in pursuing a racketeering charge. But as I said when I presented, that there would be some cases where we will not prosecute the suspect as part of the racketeering charges, but would charge them for standalone charges. I think that yes, that is all that I wanted to speak to.
No, thank you, Advocate Kanyani. So, Honorable Chair and honorable members, we really do take it to heart the general call made by the honorable members to see the matters through. It is our duty, and of course that of the DPCI, to ensure that the matters are speeded up. So we will go back, and as we continue to engage, to ensure that those case plans that have been agreed to are followed through. Thank you very much.
Honorable Chance, you can come through now.
Thank you very much, Chair. Yes, I think, thank you for the answers to those questions, but I do think it's clear now to the committee that the non-appearance of SAPS and the DPCI is really critical. And I would request, Chair, that you write to the Acting Police Minister, Mr. Kuchalia, and the Commissioner to request their presence before this committee to account for what is clearly a huge blockage. And as we've heard, it's the SAPS that has to take these cases forward now. And if they don't have the core evidence, they're not going to be able to do it, let alone get it done by April next year. The other thing I just wanted to point out in terms of Mzukizi Makatsi's case, I mean, it's quite extraordinary that the NLC, over a period of 3 or 4 years, spent 9 million rand on legal fees to defend Commissioner Mampani, who received simply a small amount of 200,000 rand. Again, it just shows the huge imbalance of state-funded resources against individuals who have got to defend themselves. It really is, again, a miscarriage of justice. Just one other question, Chair, if I may. There's a case that I'm aware of because I happen to be a constituency head in Soweto of Mr. Rapatsi Monsho, who's the former chairperson of Jersey FM radio station, who I understand has also been charged and appeared in the Protea Magistrates Court on charges of 23 million rand of theft of lottery money. Could we get an update on that, please? Thank you, Chair.
Thank you very much. Any responses from the last question? Because the rest are fine. SIU and then NPA, if there's any further information on the last question.
Thanks, Honorable Chair. From our side, we'll also deliver the written response regarding the budget. I think that's the only matter that we were unable to answer because we don't have the numbers now. Thank you.
No, thank you, Chair. On the last question, we would also have to just engage with our colleagues at SIU whether there was any referral around the Josie manager. But if he has already appeared in court, then we should be able to trace the details, and we can submit a written response, because at the moment we do not have those details on hand. Thank you.
Thank you.
Thank you very much. We will follow up with the team with regard to SAPS and that other entity, DC. What's that other entity of the police now?
The DPCI.
DPCI, yes, that's the correct one. We'll make a follow-up and ensure that there's interaction. We've done everything on our part to try and make sure that we align. Initially, we had to accommodate the transition of the NPA head from SIU to NPA and the minister's availability. So we played around, we talked to all the stakeholders, but it became almost impossible. And postponing this meeting, I think, would have they further delayed us. So that's why it was important that we proceed. Based on the information that is before us, we should be able then to interact with SAPS and ensure that the other entities are also fully briefed. We'll share their presentation with them so that they can align and give us specific reports that are relevant to them. With that, and do we have other business of I see there's a hand.
Yeah, the minister is on the platform, Chair. If
Honorable,
also you maybe want to.
Yes, Honorable Motibi.
It's my hand, and I'm very apologetic that I speak after you.
No problem.
My colleague has written in the chat requesting the name of the accused, if it's at all possible. We can still follow up and just really find out, but it would really assist if we can get the name of the accused through the secretariat of the committee, and then we can give feedback. That was on the last committee, on the last question by Honorable Chance. Thank you.
No problem.
I've just written the name in the chat, Chair. I've just written the name in the chat.
Thank you very much. I appreciate that.
Okay. Andre, you were saying the minister is on the platform as well.
Yes, Chair, and you may want to indicated earlier, you may want to comment, Chair, at the end of the proceedings. I don't know if you still want to do that, Chair.
Yes, we still have a bit of time. So the problem. Minister, over to you. Minister.
Thanks, Chair. There was a bit of confusion earlier whether reference to minister is myself or Minister Kupai. But on my side, safe to say that the issues that have been raised by members of the committee are the same issues that we are engaging the NLC on and focusing our attention on in relation to the investigation and finalization of the issues. And we share the sentiments that have been expressed in the committee. Thanks.
Thank you very much, Minister. Much appreciated. I think, colleagues, this brings us to the end, and unless we have another business of committee.
No further business, Chair. We concluded the business of the day, Chair.
Thank you very much. Let me take this opportunity to thank the Minister, SIU, NPA, and members of the committee, members of the media for this engagement. I'm confident that we will be looking at the dates to conclude on this matter. And I'm certain that you will leave no stone unturned to make sure that you get to the bottom of the problem, because the ultimate loser are the poor of the country. So it's important that as these institutions of democracy, we do our best to make sure that we bring everyone to book, those who have wronged the state. With those few words, the meeting is officially adjourned. Thank you very much.
Thank you, Honorable Chair and Honorable Members and the Minister. Thank you.
Thank you, Chair. Bye, colleagues.